Hello, everybody. It's Mark Pruitt with Strategic Estate Planning Services for another strategic money tip. Today, I am joined by a good friend and attorney, Mr. Lorne Book. Appreciate you being here.
Thanks, Mark. Thank you for having me.
I hear you're working right now on about 3 hours of sleep.
That's right.
For those of you that don't know, which I'm sure you don't, is Lorne and his wife have just adopted a brand new baby girl.
Yep, that's right.
So tell them a little bit about your family, because this is going to be a new addition, a whole life changer for you.
Absolutely. Everything's changing now. So my wife and I have been married for 10 years this month, actually.
Congratulations.
And we have three biological boys, and they are awesome. And so now we are venturing into all things pink. That's right.
Yes.
That's right. So we're very excited. But yes, working on limited sleep. So no big deal. We'll get there.
You'll get there. Well, I'll tell you, girls are different. I have two of them,
right,
and love them to death, but they are certainly different than boys. That's a good thing. And on both sides, they both bring strengths and weaknesses, I guess you could say, because God made them all differently.
That's right.
But at least your wife now is not totally outnumbered, because there's now a girl.
There's balance.
There's
balance in the house.
That's right.
That's right.
Well, fantastic. I'm glad for you. Today, what we're going to do is we're going to talk about, basically in this particular section, Estate Planning 101. And then we'll have another video after this that'll be an Estate Planning 101 Part 2. We're going to break this down in segments that we think will be better for everybody. The first thing I will ask, Lorne, is basically the most basic question. When I go in and I'm talking with clients and I ask them and I say, "What do you have your legal documents? What documents do you have?" I inevitably get, no matter what the topic is and what type of documents we're talking about, I'll either get, no, we haven't done anything, or yes, we have our documents in place. And I'll say, "And what is that document?" And they'll say, "A will." Mm-hmm. And so there are different sides of documents, what I call, when you pass, what documents do you need to, what are your options that you should have in place beforehand?
Right.
And then what documents you should have in place, what I call the living documents. Mm-hmm. So in this particular section, what we're going to talk about is the dying documents, dying options that you have when a person passes away. They've kind of gone down one road or another road or another road or another road. So I would say the first document is basically the easy one, none. So they have no documents. They've done no planning whatsoever. They're always meant to do it. They've not done it. What does that do to the estate and to the family if they have chosen that particular option of "I've done nothing"? Sure.
So, we're talking about an individual
mm-hmm.
who has passed away. They own some things. Could be a bank account. Could be a house. Could be undeveloped land in Oklahoma. Right. Could be personal property. That's
mm-hmm.
exactly right. So they've passed away, and they have no written plans for how the ownership of those things are going to move from them to the next, down the line, basically. And so this is where we kind of jump off with the idea of what does it even look like to transfer that kind of ownership if there's nothing written down on how to actually do that.
Right.
So if you have engaged in any sort of estate planning or even Google searched it, you've probably seen some language out there. We practice in Texas,
mm-hmm.
right? So if you don't have a plan, the state of Texas has a plan for you. And that is true.
And that's called what? What do they call that? Dying intestate?
They call it dying intestate. In
Yeah.
other words, without testamentary documents, right?
Got it.
So dying intestate. And the Texas Estates Code, which is the legislative code that governs how all of this works, does have default rules for who owns what after a person dies. And it's dependent on a number of different things. It's dependent on, is that person married? Is that person single? Does that person have children at all? Does that person have children all from one relationship? Does that person have children from a blended family situation? And the code has all of these little rabbit trails, if you will, to chase to discover who the legal heirs are. But it's not enough to just know who the legal heirs are. And what I often tell clients whenever we're talking about this scenario where a person has passed away with no will is that we essentially procedurally double everything. So if you're familiar with the term probate, so probate is the court process of getting approval for where your stuff is going to go and who's going to take business responsibility for getting it there. In that probate situation with clients who pass away with no plan documents, we tell them to double everything. First of all, you're required in any sort of probate or court proceeding representing a person's estate, you cannot do it on your own unless you're a lawyer. Therefore, you have to hire a lawyer. So one of the first things off the bat that we're telling clients is expect an increase in attorney's fees because there are going to be, in the state of Texas, at least 2 attorneys, one to represent the actual estate and one to represent what we call the unknown heirs. The court has no idea who your family is because you haven't told them in your documents who those people are. And so it's not enough to just put it down on paper, this is my wife, these are my children, or these are the survivors. A court-appointed, impartial second attorney has to come along and verify that information.
Okay.
So right off the bat, we know that the costs are going to go up.
Okay. So if I, when I talk to people, and I've talked to lots of groups through all the years that we've been in business, and here's the question I ask families, and I'll ask you as you're watching this video, is if I said in a basic question of, would you prefer court control or family control? Which one would you prefer? If I said, would you prefer it to be public or private in regards to settlement? Which would you prefer? Take a second and answer that question to yourself. Would you prefer it to be public or private? Would you? And you know what the answer is? 'Cause I know what it is. Because everybody answers the same question. Well, I'd rather it be private. I don't want it to be public. I don't want everybody knowing all my stuff. The other question is, would you prefer court control or family control? I've never once had anybody tell me, Lauren, that it should be court controlled. Everybody says family controlled. Well, in order to have it family controlled, in order to keep it private, there's some planning that has to be done along the way. And doing nothing is going to ensure that it's going to be public, and it's going to ensure that it's going to be court controlled, not family controlled, because you didn't give your wishes. So the first thing is, in recapping, if you had no planning whatsoever, in a simple version, would you say that the court's going to provide a will for you?
Well, the code will provide a roadmap for who gets what.
Right.
And that's a key issue because maybe your goals and what the code says aren't the same.
Right.
Maybe you don't want your surviving spouse to inherit every single thing that you have, or maybe, more importantly, maybe you do. Maybe
Right.
you do want your surviving spouse to inherit everything. But if you pass away and you haven't put that down in writing in a legitimate planning
The
document,
courts are
whether
going to
it's a will or
decide
trust,
it then.
that's exactly right. And
Okay.
or the default rules are going to apply. And that's where a lot of people miss the boat because especially, and I would say more in the instance of I want to leave everything now to my spouse, but the code now won't allow me because it has default provisions for bringing my children in as heirs. We see clients, maybe they have 2 kids, they're on very good terms with one, they're on very bad terms with the other. If they don't have plan documents in, any intention that they had to provide for one and maybe not provide for the other, those things go out the window.
Okay, so I would say, so that's option number 1, do nothing. Option number 2 is you hire an attorney and you draw up a will. So take them through that. What does that do in a simplistic version to say, okay, instead of me doing nothing, I am going to go and at least have a will, whether it be an attorney-drawn will, honestly, even a holographic will. It may not be necessarily recommended because it may not cover everything, but I would say the best effort probably is I encourage clients to get with an attorney to draft a will.
Sure. So can I actually substitute your option 2 for an option 2 that we see very commonly?
Sure.
It is the do-it-yourself option.
Yes.
So I don't want to hire an attorney because I don't know any attorneys, or I don't trust attorneys, or I think they charge too much, although I've never actually sat down with one. And so now I'm going to take it upon myself to do something that I should probably never do, which is render myself my own legal
That's
advice.
like operating on yourself.
It's like cutting your own hair.
Yes.
That's exactly right.
Correct.
So we see this from time to time. And, I'm not going to say that every client I've ever sat down with has totally missed it, but there are a number of ways that clients can mess up good planning or good goals by taking it upon themselves. You mentioned one earlier, a term that clients may or may not be familiar with, the notion of a holographic will. That's a will that you write out
By hand.
And there are very strict legal requirements for when those documents are effective and when they are not. The same with a typewritten document. There are very strict requirements, and if you miss one of those requirements, if those boxes aren't checked, then the cost of having that document approved by a probate court, and we'll talk maybe about the Texas two-step in a minute for actually legitimizing a will, any will that you create. The cost of doing that just becomes exponential for those who are not skilled and informed in all these little nuances about estate planning and elder law.
And the point really is, in the end, I would see and say is, you want to make it easier on your family. In fact, that's the question I ask people. Do you want to make it easier on them, or do you want to make it harder on them? If you want to make it easier on them, then you have to take some steps to make it easier on them. Because you and I hear the after effect and the aftermath of, I don't ever want my kids to have to go through what I just went through with my parents. And I hear that all the time. And so they want to make planning easier on their kids going forward when something happens to them because of the nightmare they went through with their own parents.
The most common goal, whenever I ask clients, what are your goals in getting your estate planning done? Their number one goal is to get it done. Their number two goal is to make it easy on my family. Usually because they've gone through something with an aging parent, with a parent that's passed away. Maybe they've been an executor of someone's estate before, and it's been a mess, and they don't want to have to go through the mess.
And so would you agree that a will, whether it be attorney-drawn, at least attorney-drawn wills, getting it done right, getting the right code in there, meeting the litmus test that the state requires, is a good option, and it's a better option? Would you say it's a better option than doing nothing?
Well, it's a certainly better option than doing nothing. And this is probably a good time just to simply interject that, what we're talking about around the table is educational.
Sure.
It's not meant for legal advice. It's
Right.
not meant to form an attorney-client relationship with anybody that's watching or anything like that. But yeah, I would definitely agree that doing something is better than doing nothing.
Right.
But that's kind of like saying that a D is better than an F. You still can't bring that home to mom.
Right, exactly.
So we want our clients to have A plus work
Right.
whenever it comes to their planning, for
to
sure.
make it easier on their families as well. So another option would be is doing or exploring the option of a trust. Does not everybody, I would think you would say not everybody needs to have a trust, but a trust is another option. Maybe explain to them simplistically, why does a trust avoid probate and a will would not avoid probate in regards to the way assets are titled? Why is
Sure.
it that one avoids probate and the other one doesn't?
So just at the offset, when we mention just the concept of trusts, people sometimes get a little intimidated by that because they think they have to have high degrees of wealth in order to use trust as part of their estate planning. That is not true.
I think the state of Texas, you correct me if I'm wrong, says the limit of a full-blown probate is basically anything over $50,000. Is that still current?
Well, that's for what we call an independent administration, yes. Now, there are smaller probate procedures
right.
that are still considered probate actions that aren't what we would call the independent
Yeah,
administration.
the more simplified probate is what I call it. It's the words
Right.
I use. They're more simplified probates versus the full-blown on the other. And that's based on the amount of assets. And the reason, honestly, I think the courts make it simpler is because there's nothing there to hardly deal with, but yet they've still got to get names off the accounts.
That's right. So understanding that everybody can use trusts, right? They're for anybody, but they're not for everybody.
Correct.
Might be the best way to say it. The other thing that I would counsel clients on trusts is that they're like trying on shoes. There's no just one trust. There are a multitude of different trusts that accomplish a whole bunch of different goals and all sorts of things. And what we're talking about most commonly is the use of a revocable living trust as an alternative to a will.
And that means revocable means they can undo it. They
Correct.
can revoke, they can change it. It doesn't lock them in.
That's exactly right. The type of trust that a client can set up, can amend as they need, can choose to use it or not use it. And those types of trusts do have, they have some benefits if a client's goal, again, is making the transition process at passing easier on family. So you mentioned one, avoiding the probate court. And here's how I set this up for clients. If you think about yourself as an individual, you are, once you become 18 in the eyes of the law, you are a legal entity. You are the legal entity. And you can go and you can set up a bank account in your own name, and your signature draws checks out of that account. Right? You can set up a credit card, and your signature authorizes the bank that's behind that credit card to push that money forward. You can sign contracts. You can buy a car. You can sue somebody, or you yourself be sued.
Right.
These are all the rights and responsibilities that the law gives to legal entities, whether it's you, the individual, or kind of a domestic entity like an LLC or something like that. The point is that as long as you are alive, you have the autonomy over everything that you own, everything that lives under the name of you, right? Your bank accounts.
So the example, I would say, another example that I use for my own family is I own a home with my wife, but the difference is my trust actually, it's restyled. So my deed is restyled in the name of my trust. The deed on my, the title on my deed does not say Markandella Pruitt. It says the Markandella Pruitt Revocable Living Trust. So who owns my property? Who owns my house? My trust actually owns it.
Right.
But as a trustee, we control it. We make all the decisions for our home. It's just not in our name.
Sure.
And that's one of the things that helps make it avoid probate, is because we've already removed our names from the assets, but yet we don't lose control of our assets. And and I'll throw this in there. Let's talk about this. We'll probably talk about this again later on funding of trust. But many people think, especially in a community property state, they'll come in and they'll say, well, when I die, it's honey, I love you, everything's going to go to my wife. And so maybe address that in regards to, as long as she's living in that house, she has certain rights. But the second she wants to sell that house, whose name is still on that deed, and what is she going to have to go do?
Sure. So I would say those situations are common. They're also very fact driven. So let me address how the law treats husbands and wives in general. Okay. And I'll use that to tie back into the conversation we were having about the legal entity. So when a husband and wife, let's say that they own property together, right? They showed up, you and Della showed up the day that you bought that house. 2 pens, 2 signature lines, and a mountain of paper. Right. And before you transferred it, if we were to look you guys up in the appraisal district records, we would have seen Markandella Pruitt as owners. And there is a great misconception that just because we're married, if my spouse passes away, that I automatically inherit that house that we were living in, co-titled in both of our names, 100%. Not so. Right. Now, there are some planning techniques where we can make that happen, but that's not the default rule. In a community property state like Texas, husband owns 50, wife owns 50, and together they make up the 100%. So what I was talking about earlier, right, whenever the law looks at us as a legal entity, and as long as we're alive and kicking, we have the ability to transact business on behalf of ourselves. But when we pass away, there's no brain, no hand that's physically left behind that can legally transact business on what is left over, which is now called our estate. Okay. If I own a checking account in the name of Lorne, and then I die, that checking account now is owned by this new thing that's created called the estate of Lorne. but there's nobody physically present that can transact business out of that account until a court says you can.
Right.
And that is a key component of what the probate process is about, is appointing a legal representative to transact business on your behalf after you have passed away. So now, moving back to the husband and wife arrangement. If husband passes away, there's no legal representative that can transition his 50% ownership to wife, assuming that's where he would want it to go,
Right.
unless and until a court says that wife is the representative of husband's estate. Trust planning, the type of trust planning that we're talking about, is a mechanism for avoiding having to go through that process, because exactly as you said, if you take the individual ownership that you have and you transfer it not to a different entity, but to a different version of yourself, a
Right.
version that we call the trust, that transition of ownership has already occurred, right? One of the ways that I just break basic estate planning down for clients and talking about the difference in wills versus trust is, if we start from the foundation that in order to move your ownership after your death to somebody else, there's going to have to be some work that's done. Wills would have someone else, not you, do that work, right? The person that you name in the document,
Right.
your spouse, your oldest child, your brother, whatever. Trust planning allows you to take the bull by the horns, to do the work now, and to have that transition already having take place.
That's part of what I call family control versus the court control.
Absolutely.
Yeah, makes a big difference. So hopefully this has helped you a little bit. I know in some cases we've got into the weeds of this, and that's why we always tell you want to consult with an attorney. You want to talk about your specific family, your specific setting. If you've got a blended marriage, what I call a Brady Bunch marriage, where you've been married before and you've got your set of kids, they've got their set of kids, the spouse does, and I can tell you when one of you are gone, there can be issues that can come up. We want to make sure that the bottom line is that you write the rest of the story and that the courts don't have to write it and that your children don't have to write it. We want you to make up the rest of the story in regards to where you want your things to go. And so in recapping, you can either do nothing, you can go draw up a will, or you can explore trust. Those are your three basic things in regards to how you would do estate planning 101 on when you would pass. And obviously you want this done, has to be done before you pass, because if it's not, then you're going to default to number one, which is the state's going to be in control of making the decisions on your behalf for you. Hopefully this has been helpful. It's another strategic money tip. I would encourage you, why don't you go ahead and give them, I think it'd be good, give them your phone number that they can call. You can obviously go to, I think it's booklawfirm.com. So
Correct.
booklawfirm.com, that you can look that up. But you give them the phone number in regards to calling you if they've got questions.
Absolutely. So our office is located in Carrollton. You can reach us on the web at www.booklawfirm.com. It's book like the one that you read. Or you can give us a call, 214-305-6974. We would love to sit down and talk with you. There are a myriad of planning options, but it takes sitting down with someone who knows those options and can walk you through it in order to get the estate plan that fits you and your family needs the best.
Great. Thank you, Lauren, for being here. Appreciate it. Thank you guys for joining us. We'll look for you next time on a Strategic Money Tip. Take care and God bless.
Thank you so much for joining us for today's Strategic Money Tip. If you have any questions about the material covered in today's video, or you'd like to speak with someone from our team, simply call our office at 1-800-381-8870. Also, while we have your attention, click the link below to watch our latest video. And to see more videos on tips just like this one, make sure to click the logo to subscribe to our channel. On behalf of the team at Strategic Estate Planning Services, thanks again for watching.